Please be seated. Record should reflect that we're in session on State of Wisconsin versus Kayle Fleischauer. The appearances are as previously noted. All 14 of our jurors again have arrived this morning, and we are at that point in the trial where the defense is calling its witnesses. Ladies and gentlemen, I trust you all had a good weekend. The weather was certainly conducive to a number of activities outside. So again, thank you for your efforts today. And with that said, Mr. Gray, your next witness, please.
Defense calls Dr. Mary Dunn to the stand. Dr. Dunn, will you step forward, please?
And Dr. Dunn, if you'll come towards me, please. And if you'll face the clerk and raise your right hand.
Do you swear that the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God? I do.
Thank you. Come over here, please. And doctor, if you'll swing that microphone arm in towards you. Thank you. Mr. Gray.
Thank you, Your Honor. Are you a doctor?
Yes, I am.
And what kind of doctor are you?
Neurosurgeon.
How long have you been a neurosurgeon?
31 years.
I'm going to show you what is earlier marked Exhibit 328.
That's my CV.
Okay. Your curriculum vitae,
Yes,
is it accurate?
yes.
Read off the 328, please.
As soon as I have the witness's name, I'll know whether I can.
Mary Elizabeth Dunn,
And Dr. Dunn, can you spell your last name, please?
D-U-N-N.
Thank you. Any objection, Mr. Kaiser? No. Thank you. Received.
Dr. Dunn, were you hired to review this case and my client Kayle Fleischauer's conduct prior to after the death of his son?
Yes,
And did you do that?
I did.
And you have an opinion as to a reasonable degree, well, back up. Have you, in your career, observed loved ones, relatives who have been confronted with the death or serious injury of a loved one?
Yes,
Many times?
hundreds.
Okay. And you've treated patients with gunshot wounds over the
Yes.
years?
Yes.
And you have to wait till I finish my question.
Oh.
Okay. And in those years that you've treated victims of gunshot wounds, have you observed the bereavement reactions of the loved ones and the relatives?
Yes.
And what did you observe?
Well, if we look back in history and talk about bereavement and grief, there's usually 5 steps. And the first step is denial. And that's where the sudden bereavement emotions enter into the picture. Then ultimately there's anger, bargaining, depression, and acceptance. And but in the denial phase, we see in the emergency room all sorts of reactions from family members. The gambit, stunned like a deer in headlights, silent, crying, laughing, just the whole gambit of emotions. And so we always are very, very cautious about that because we have to guide the individuals who are experiencing this loss carefully. So we usually have the counselors come down and visit with the patient's family in the emergency department. And we do a variety of things to try and intervene to help people through this phase. But the denial phase is pretty dramatic. And then if you throw alcohol on top of it, you can get anything. You can get laughing, you can get, like I said, crying, you can get screaming, you can You know, we had one patient's brother charge into the room because we didn't have the locks on the doors. And he came to the door and he said, "You're hurting my brother." Well, we were trying to save him. but the emotion was just so strong that we had to actually get the police to move him out so we could conduct what we needed to do. So the whole gambit of emotions can be seen in the acute denial phase.
And you mentioned alcohol. Is that aggravated by somebody that has used alcohol?
Oh, God, yes. And the reason is that alcohol changes the inhibitions. And so if someone is inclined to laugh or cry, or they'll just do it more because the inhibitions are released by the alcohol.
Thank you, doctor. That's all I have.
Thank you. Mr. Kaiser.
Thank you, Judge. Doctor, you said you're a neurosurgeon, is that correct?
Correct.
So when people come into the emergency room with gunshots with their families, the first doctors who see them are the emergency room doctors, correct?
Correct. But I take that back. I need to change that.
So that wasn't correct?
That was not correct. We're often called before the patient even hits the door. And the reason we're called is that the EMS people are the first ones to see the patient. And they call and say, "This is coming in." And so frequently I'm in the emergency room at the same time the ER doctor is.
Thank you. And when you said we do a variety of things, the we includes you, the ER doctor, as well as the counselors who are called in to actually do the caring for the family. Is that correct?
Correct.
Where did you do this work?
Regions Hospital.
I'm sorry, what?
Regions Hospital.
Which is where?
It's in St. Paul, off of 94. It's a level 1 trauma.
Thank you. You said that alcohol will cause people to do more of things that they're inclined to do anyway. Is that correct?
Correct.
And you said that some of the things that you've seen some of the reactions you've seen from people include laughing, correct?
Yes.
Crying, correct?
Yes.
Screaming, correct?
Yes.
Accusing caregivers of hurting the person, correct?
Yes.
Have you also seen people demanding that you, the caregivers, do more to help the person?
Frequently.
This is at the hospital, correct?
Correct.
Your practice wouldn't ever cause you to actually be at the scene immediately after a shooting, is that
No.
right? What you said, and correct me if I'm wrong, what you said was you reviewed the case, is that right?
Correct.
Show you what's been marked as Exhibit 182 for identification. Can you tell me if you recognize what that document is, please?
This is my statement about acute reactions.
So you're saying that's a statement, is that correct?
Well, it's a letter.
It's a letter. Is it the only written document that you filed, or, I'm sorry, let me ask it a different way. Is it the only written document that you provided to the defense to explain what you reviewed and what your findings were?
Yes.
Move Exhibit 182 into evidence.
No objection.
Received.
Yes. Oh, sorry. Ask to publish 182.
Yes.
So it's addressed to Mr. Gray, is that correct?
Correct.
And the first line of it, it says, "I have discussed with you." Is that right?
Correct.
Meaning you discussed with Mr. Gray what he represented to you to be the facts of the case. Is that correct?
Yes.
You reviewed no other documents, right?
Correct.
Just so we're clear, what you've described to us is the experiences that you have had, correct?
That in addition to research.
Your
That's why I
work.
brought up Elizabeth Kubler-Ross, is that she published her book in 1969, and it's kind of the Bible for understanding some of these emotional reactions.
And that was to help prepare you to deal with people in the emergency room.
Yeah, yeah.
All right. But your actual work is as a neurosurgeon, helping try to keep people alive. Is that right?
Oh, yeah.
All right.
But you know, it's
I
not
don't
just...
have a question pending. I've tried not to interrupt, but
Thank you.
thank you very much. Even though you've studied to prepare yourself, to help yourself deal with the families, ultimately your patient is the person who's shot. Is that right?
Correct.
The defense asked you when you started whether you were hired to do this. Is that correct?
Yes.
Total between your time talking to Mr. Gray and preparing your letter and then coming here to testify, can you tell us how much you're getting paid for all that?
The standard fee is $5,000 for a half a day.
And that's total for today, your time conversation with Mr. Gray and preparing your letter.
Yes.
Thanks, ma'am. No further questions, Your Honor.
Mr. Gray.
Thank you, Your Honor. I want to show you Exhibit 182. And And this is an email, correct?
Yes,
And it's to me on May 31 of 2019, correct?
correct.
Prior to this, I discussed this case with you, correct?
Yes,
And that's what you meant by reviewing it, correct?
yes,
Now, this email starts out, "Dear Mr. Gray, I have discussed with you the issue of sudden bereavement reactions that can be seen in the early hours and weeks after an unexpected death of a family member, loved one," right?
correct.
An individual experiencing sudden traumatic bereavement will often have strong and unexpected emotional and physical responses, correct?
Yes.
And anything about your fee that would cause you to change your mind on that? That might be a confusing question.
Yep.
Are you saying this because you charge a $5,000 fee or because it's true?
Because it's true.
Then you state the initial phase is a shock response, correct?
Yes,
You gotta look at the, you remember reading this? Okay. Symptoms vary from screaming, shaking, inability to talk, eat, drink, or sleep, correct?
correct.
Unexpected emotions occur in a state of shock.
Yes,
It is frequently seen in people that they react in ways that are difficult to control. The individual could be in complete disbelief, feel nothing initially, react strangely, such as laughing.
yes,
And you've seen these reactions in your experience as a board-certified neurosurgeon, correct?
correct.
I treat patients with gunshot wounds to the head, correct?
Correct.
All that true?
All that's true.
This is frequently a sudden event and family members experience this shock response. It is my opinion that your client experienced this reaction. I am willing to testify to the above. Is that what you sent me on an email?
I did.
Thank you, doctor. That's all I have.
Mr. Kaiser?
You weren't here during the trial so far, were you?
No,
Of the reactions that you just got done going through with defense counsel, have you ever seen people in the emergency room, the family talking among themselves, telling each other not to talk to the police?
Object to that, Your Honor, outside the scope of it.
Overruled, you can answer.
I have not witnessed that, no.
No further questions.
Thank you.
No comment.
Because it was a new line of inquiry, anything else, Mr. Gray?
While you're,
On that issue only.
yes. I don't have any further questions.
Thank you. You can stand down, Dr. Dunn. Mr. Gray, your next.
He's going through the
Thank you.
X-ray machine.
And the name of this witness is whom, Mr. Gray?
It's Dr. Jonathan L. Arden, A-R-D-E-N.
Thank you, Dr. Arden. If you'll come up towards me, please. And if you'll face the clerk, raise your right hand.
Do you swear that the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. And Dr. Arden, if you'll have a seat in the witness chair, and that microphone arm swings out to let you sit down, and then if you'll swing it back towards you, please.
Thank you, Your Honor.
Would you state your full name, sir?
I'm Dr. Jonathan Arden, it's A-R-D-E-N.
And are you presently employed?
Yes, sir.
And what's your employment?
My primary employment is that I have a consulting practice in forensic pathology and medicine. My business is called Arden Forensics PC. And I also have a part-time appointment as a forensic pathologist for the Office of the Chief Medical Examiner for the state of West Virginia.
And in order to get that employment and your other West Virginia employment, you had an education?
Yes, sir.
Would you tell the jury what your education is?
I attended college for 2 years at the Johns Hopkins University in Baltimore, and then for 2 years at the University of Michigan, where I received my Bachelor of Science degree in 1976. I then attended and graduated from the University of Michigan Medical School, receiving my MD or Doctor of Medicine degree in 1980. After graduation from medical school, I then served in 2 medical specialty training programs. I first had a 3-year training program in anatomic pathology at the New York University Medical Center in New York City. After that, I served 1 additional year of training in forensic pathology at the Office of the Chief Medical Examiner for the state of Maryland.
Are you board certified?
Yes, sir. I'm board certified by the American Board of Pathology in both anatomic and forensic pathology.
What does that mean?
Every one of the medical specialties in this country has a governing board. For me, that's the American Board of Pathology. Each of these governing boards puts together standards for education and training, and if a physician can demonstrate that he or she has fulfilled the requirements for the education and the training and is licensed to practice medicine, and then submits his or her credentials to that board, you can then sit for the examinations given by that board in each of their specialties and subspecialties. And if you then pass those examinations, you've demonstrated your competence and accomplishment and proficiency within the individual fields. And so the board actually certifies you as having made that accomplishment.
After being board certified, could you tell the jury about your employment through the years?
Yes, after I finished my training, my education and training and became board certified, I first had a total of 20 years in full-time government service as a medical examiner. I worked in 4 different offices, including 9 years working for the city of New York, where I rose through several titles and finished as the first deputy chief medical examiner, so I was the second in command to that system. I then spent about 5.5 years as the chief medical examiner for Washington, D.C. At the completion of that total of 20 years, I then largely went out into the private practice, the type of work that brings me here today. So I've been doing consulting work for now about 15, 16 years. Overlapping with the consulting work, I first had a part-time appointment in the medical examiner system in Northern Virginia, which is where I live. And I did basically community-based kind of triage and case jurisdictional decisions for them, certifying deaths that didn't go for autopsies, for instance. I held that position for about 18 months. And then it's now been about 12 years I've held the part-time position in West Virginia, and in that capacity, although it is only a part-time position, I do perform the usual functions of a medical examiner. So I do participate in death investigations, I do autopsies, I write autopsy reports, and I'm available to testify in court.
And have you testified in court in the past?
Yes,
As an
sir.
expert?
I have testified numerous times as an expert in court and at deposition.
And have you testified both on the side of the defense and on the side of the prosecution?
I've been called as a witness in criminal matters both by the state and the prosecution as well as the defense.
I'm going to show you Exhibit 329.
Yes, sir.
Is that a fair and accurate description of your curriculum vitae?
Yes, sir, it is.
We offer 329.
No objection.
Received.
Were you hired to review the findings in this case?
Yes, I was.
And what did you review?
Primarily, I reviewed the final autopsy report with the diagrams and the toxicology report for Chase Fleichauer. I also, in relation to the autopsy, reviewed the autopsy photographs. Aside from that, I have reviewed both the PowerPoint and the transcripts of testimony of Dr. Mills. I've received the criminal complaint, and I also reviewed the report and in particular the videos from Mr. Burton, who did the recoil testing on the similar gun.
Do you have the, I want to show you exhibit 330. As a result of what you reviewed, did you make out that report?
Yes, sir. What you've handed me is 330 is a copy of my consultation report in this matter, which indeed was the result of my review of those materials and my reaching opinions.
We'd offer 330.
No objection.
Received.
Thank you.
Use that to assist you.
Yes, sir.
And what else did you review?
I guess I neglected to mention that I'm aware of the findings from the gunshot residue testing and the DNA testing.
And did you review Dr. Mills' autopsy? Did you say that?
Yes, sir, I did.
Okay. After reviewing that evidence, did you form any opinions in this case?
Yes, I did.
And first we'll deal with cause of death. What in your opinion was the cause of death of this?
In my opinion, the cause of death of Mr. Chase Fleischauer was the gunshot wound to the head with brain injury.
And would that be considered the substantial factor of his death?
It would be not only the substantial factor, in fact, it would be the only factor that caused his death.
All right. And did you also come to a conclusion with respect to the manner of death?
Yes, sir.
And what is your opinion with respect to the manner, first back up, what is the manner of death?
The manner of death is the circumstantial explanation for how the cause of death occurred. It is one of the two major elements of what we call certification of death. So when you certify a death, you determine the cause of death, being the disease or injury that leads to the death in an unbroken sequence. And then you also determine the manner of death, which, as I said, is the circumstantial explanation for how it happened.
And do you have an opinion based on a reasonable degree of medical certainty how this incident happened?
In terms of the manner of death, yes, I do, sir.
And what is that?
In my opinion, to a reasonable degree of medical certainty, the manner of death for Chase Fleischauer is accident.
And what do you base that on?
I base that on a number of factors, and again, just as a starting point, I gave you the definition of manner of death being the circumstantial explanation for how the cause occurred. By its very nature, being a circumstantial explanation, the manner of death is highly dependent on circumstances, and you determine circumstances largely through investigation. So I begin with, to answer your question, the basis or bases for my opinion on the manner of death, I begin with the investigation. Investigation, as I understand it, is that we have three people in the home that night, Mr. Kayle Fleischauer, Mr. Chase Fleichauer, and Ms. Summer Fleischauer. The reports from the people on the scene, the people who were there, were that they go their separate ways to go to sleep, go to bed. Both Kayle Fleischauer and Summer Fleischauer report hearing a loud noise. They respond from separate parts of the house to find Chase Fleischauer apparently dead on the floor with a gunshot wound. So the beginning of the investigation tells me that the two people in the house who can report the events say that neither one of them was with him when they hear the noise, and then they find him with the gunshot wound. That sets the scene for a self-inflicted gunshot wound. Judge, I'm going to ask that the portions that he refers to of the reports he's referring to that claim to have come from Kayle Fleischauer be stricken as statements of a defendant, statements of a opposing party as offered on his own behalf.
Judge, may I approach on that?
Come on up. Some things the attorneys and I need to talk about. Don't form any opinions in any discussion. Start your deliberations. We will stand adjourned for about, hopefully no more than 5 to 10 minutes. Take the jury out, please.
All rise.
Could I ask the doctor to be excused for this
Yes,
conversation?
Dr. Arden, if you'll just have a seat out in the hallway, please.
Yes, sir.
Have a seat. Record again will reflect outside the presence of the jury. As I recall, the question of Dr. Arden, it is to the manner of death, and he referred to certain statements that, as I understand, is an offer of proof, may have been made by Kayle Fleischauer to law enforcement. That was at the sidebar. Mr. Gray indicated that there is in a police report or others reference to Kayle Fleischauer reporting that he had come down from the bedroom. The state objected basically as a statement offered by the defense, which would otherwise be inadmissible, as it is a statement, so to speak, to advance the defense. I think that generally frames what we're talking about here. 90703 is the section that deals with the bases of opinion testimony by experts, and that particular section reads as follows: the facts or data in the particular case upon which an expert bases an opinion or inference may be those perceived by or made known to the expert at or before the hearing, if of a type reasonably relied upon by experts in the particular field, informing opinions or inferences upon the subject. The facts or data need not be admissible in evidence in order for the opinion or inference to be admitted. Facts or data that are otherwise inadmissible may not be disclosed to the jury by the proponent of the opinion or inference unless the court determines that their probative value in assisting the jury to evaluate the expert's opinion or inference substantially outweighs their prejudicial effect. So I think that is the section I would like both sides to focus on, as it is, I believe, the issue that has been raised by the state's objection. Mr. Gray.
Well, first of all, Your Honor, the testimony, I believe it was Coleman, that, and we have a transcript of it where my client said, no, I wasn't there. Something to that effect. Then we have the testimony of Summer Fleischauer saying that when she arrived, Kayle Fleischauer wasn't there. She saw him coming up from in the hallway from either the bedroom or the bathroom.
And I don't mean to cut you off, Mr. Gray, but that's not what the doctor said. The doctor reported Mr. Fleischauer reported X.
Oh, okay.
And I don't arguably going to have a lot of heartburn if you frame the question assuming that witnesses in this case have testified to A and B, which I think you just outlined what Sergeant Coleman may have testified and what Summer may have testified to, that's a different issue than the one I'm being asked to address, I think, Mr. Kaiser. Would you agree?
I do.
Thank you.
Well, I could go talk to him and we'll
Well,
straighten it out.
again, I don't care how you prepare your witness, but
Judge, just, I can narrow this in on the fact that is at issue in my mind.
Okay.
And that issue is for him to say that the reason Kayle Fleischauer came out of the room was because he heard the gunshot, all right? I don't dispute that he wasn't there when Summer was there. I don't dispute that he came out from the hallway. But the only way he can assert that he came out because of the gunshot is because in his report, and I'm actually appreciative that counsel counseled his witness not to talk about, quote, the last trial, unquote, but in his list of things that he reviewed according to his report, he says he reviewed the prior trial testimony of Kayle Fleischauer. And my position is this defense cannot bootstrap the prior testimony of Kayle Fleischauer into this record with this doctor.
and I agree with you, Mr. Kaiser. That's why I was trying to frame it
Appreciate
as
Thank you.
statements of Mr. Fleischauer, which otherwise are not going to be admissible unless he testifies, and we don't know that at this point. I'm not going to inquire at this point. So, Mr. Dre, again, if you can frame your questions on the assume that A and B have said X, did that help form your opinion as opposed to what your client may have testified in trial 1? Thank you. Let's take about 5 more minutes and then we'll bring everyone back in. Thank you.
All rise.